Hello, and welcome to the third edition of Know Your Rights. I'm attorney Gloria Allred, and during our previous episodes of Know Your Rights, the attorneys from my law firm, Allred, Morocco, and Goldberg, and I discussed COVID-19 workplace issues, sexual harassment in the workplace, and sexual abuse of children and of adults. If you're interested in watching those prior episodes, you can find them on my Facebook page or on our law firm's website. Today, we're here to discuss your rights relating to workplace age discrimination, race and national origin discrimination, and wage and hour claims. Our law firm has experience successfully handling these types of employment claims for over 40 years. I'm joined today by three attorneys from my firm: Marcus Spiegel, Maria Diaz, and Byron Lau. Marcus will discuss age discrimination. Maria will discuss race and national origin discrimination in employment, and Byron will discuss wage and hour claims. Please note that all of us on this panel are licensed to practice law in California, and the answers we're going to provide are specific to California law unless otherwise noted. I am, however, also licensed to practice in New York. The law may be different in other states. The statements we are providing are not meant to be taken as legal advice for any one particular case, but instead are general statements of law. Let's start with age discrimination. Marcus, will you explain who is protected under the law and who is not protected from age discrimination in employment?
Sure, Gloria. Well, folks may be surprised to learn that an employee or an applicant for employment that is 40 years or older is protected under the law. On the other hand, this means that anyone under 40, unfortunately, cannot assert an age discrimination claim.
Well, what are some examples of age discrimination in the workplace?
Well, age discrimination can occur at any time during the hiring, employment, or firing. It's when an employer makes a negative decision based on someone's age, such as not hiring or not promoting someone because they're considered too old. It's rare for an employer to directly say, "I'm not hiring you because you're too old," but we do see examples of an employer putting out, for example, job advertisements looking for someone to join a, quote, young, dynamic team. And it's really important to note that an employee may still have a case for age discrimination, even if the employer does not necessarily intend to target the older workers. A common example that we see is when an employer gets rid of a large group of employees because they're the highest wage earners. However, because employees generally make more money at the end of their careers when they're older, this type of targeting based on salary can have a higher negative impact on older employees than on younger employees. So terminating older employees in these situations can probably bring a claim for age discrimination, especially if the employer replaces them with someone who is younger.
Marcus, we're hearing quite a bit about mass layoffs during this COVID-19 crisis and reductions in force, which are often called RIFs. When a company makes these layoffs, are there any rights that older workers, those over 40 years old, should be aware of?
Yes, there are, Gloria. First, employers of a certain size typically must provide at least 60 days notice to their employees before they can lay off a large number of them. However, given what's going on with the pandemic, the 60 days notice may not always be possible, in which case, at least in California, employers have to provide as much notice as possible. In addition, an employer is required to provide an employee who are laid off with a chart that lists the positions and ages of those who were and were not laid off. Employers may also provide those employees with a separation or severance agreement. And workers over 40 should know that they have the right to revoke their acceptance of such a severance agreement up to 7 days after signing it.
And that's very important because so many employees are being asked to sign severance agreements. So it would be a good idea for those employees, perhaps if they think they might have an age discrimination claim or a sexual harassment claim or any such claim, if they're over 40, consult an attorney. We've had a lot of people contacting us about that because they don't want to give up those claims. Marcus, you stated that it's rare for an employer to come out and directly say, we're laying you off because of your age. Can you describe other evidence or proof that can be helpful to an employee to prove an age discrimination claim?
Sure, and that is why the chart I just mentioned is so important in a reduction of force situation that you just mentioned, because the chart provides a great way to compare the ages of those who were and were not terminated. That said, really anything that shows a negative effect on an older age group can be evidence. So you can look at other things like how old your replacement was or what kind of language was used for the employment decision. And as you just mentioned, if you suspect you have a claim, the best thing to do is to contact an attorney and they can advise you of your specific rights in that situation.
Thank you very much, Marcus. Let's move on now to discussing race and national origin discrimination. Maria, what is race or national origin discrimination, and how does this issue arise in the workplace?
Race and national origin discrimination are similar, but slightly different in some respects. Race discrimination happens when an employer bases his hiring decisions or firing or on a person or based on physical characteristics associated with a race, such as skin color, hair texture, facial features. National origin discrimination is a little different. In national origin discrimination happens when an employer discriminates based on somebody's ethnicity, place of birth, or characteristics linked to ethnicities, language, accent, or a last name. Some examples of this occur in the workplace. For example, an African-American worker who is the best qualified person for a job being passed over because he has dreadlocks. Another example is when a Latino employee gets written up for an absence while a Caucasian does a similar absence. One final example is of an airline that won't allow anyone who looks like they're from the Middle East interact where they interact with customers. The most thing that I can say about this topic at this point is that people of the same race can discriminate against. That's important to remember. For example, a light-skinned African-American person might treat somebody who's dark-skinned African-American more unfavorably, or a Cuban manager might prefer to hire people of Cuban descent over, let's say, Mexican employees. The fact is discrimination, and it is unlawful in the workplace.
Good points, Maria. Can an employer require an employee to only speak English at work?
Generally, it is a law of an English-only policy unless it's for business necessity or for safety reasons. If an employer creates a rule where they are requiring employees to speak English only for a discriminatory reason, such as getting rid of all Chinese employees, or if they're not equally applying the rule, or if the rule is not required, like I said, for sheer efficiency, it's unlawful. Some examples are an employer cannot require employees to speak English only at all times, including their breaks. They can also not punish one worker who, for example, speaks Russian while not punishing another worker who speaks Spanish. More importantly, to emphasize in this topic is that an employer preference for an English-only policy is not sufficient to make it legal.
What should an employee do if that employee feels that he or she is being discriminated against at work?
Excellent question, Gloria. We get a lot of calls in our office on a daily basis from employer help. The most important thing you can do if you believe you're being targeted for discrimination is that you need to make a complaint in writing to human resources or to a supervisor. You need to make sure that you keep a copy of that complaint because you will need it In a lot of these cases, what happens is employers will deny that you made a complaint of discrimination unless there's any evidence of you having made such a complaint. That's why the written complaint is important. The other thing that you can do is you should gather any documents, any texts, any emails, performance evaluation, anything that you have that can show that you've been treated differently by your employer, your race, or national origin. You should also make a list of any witnesses who may have seen how you've been treated or mistreated by your employer. Number 3, you can also make a timeline of the events showing the circumstances and the facts under which you've been discriminated. And number 4 is really important. You should, if you don't know what to do, come frozen because of what's happening to you, contact an attorney immediately. Contact an employment law specialist who can help you with these questions. And finally, you can also file a charge with a government agency, either the state, which is the California Department of Fair Employment and Housing, or the federal government, which is the U.S. Employment Opportunity Commission. Either way, you need to stand up for your rights.
Maria, can an employee get in trouble, be retaliated against, for example, if they complain that they're being discriminated against at work?
That is a question that we get very often, Gloria. And unfortunately, although it is absolutely illegal to retaliate against someone who makes a protected complaint of discrimination in the workplace, it happens very often because employers will retaliate, unfortunately. The obvious forms of retaliation are you being fired after you make a complaint, you being demoted, your hours being cut, or even being threatened with any of those things. You can also be retaliated in more subtle ways. For example, you can be excluded from meetings or be excluded from giving information that you need to do your job, and isolated from other people in the office. You have, again, the right to make a complaint of discrimination if you feel you're being discriminated in the workplace. You also have a right to be free of retaliation. If you believe you've been retaliated, again, contact an attorney who can advise you.
Thank you very much, Maria. Let's now turn our attention to and discuss wage and hour claims, which is our last topic. Byron, workers often call us for consultations and they think they only have a claim for discrimination, harassment, or retaliation. But many also have a potential wage and hour claim. Byron, can you describe some of the common wage and hour claims that we see and what they are?
Of course, Gloria. Plainly put, wage and hour violations are wage theft, not paying a worker correctly for all the hours they have worked. That could be for overtime if an employee must work 12-hour or 24-hour shifts, or for hours employers force employees to work off the clock. Employers often misclassify employees and call them independent contractors or change them from hourly to salaried employees to avoid properly paying workers for overtime hours or to avoid providing them with benefits. The test to determine whether a worker has been misclassified has changed in the last couple of years and is still shifting in the courts today. So it can be hard for an employee to understand these laws without consulting an attorney.
Which types of jobs, Byron, typically have the most wage and hour violations?
Well, Gloria, wage and hour issues can arise in any industry and at any workplace. However, we've represented many clients with unpaid wage claims in jobs that require work in people's homes. For example, nannies, caretakers, housekeepers, and resident apartment building managers. Employers of these domestic workers often are not aware or don't believe that California's employment laws apply to them. They're wrong. These workers are too often misclassified as salaried employees, which can deprive them of receiving their full wages. An employee in this situation would likely be owed unpaid wages and overtime, in addition to other penalties required by the law. These unpaid wages and penalties can quickly add up, since many nannies and caretakers end up working long hours on a daily basis. We have fought for and recovered unpaid wages and penalties for these wronged employees.
Byron, if a nanny or a caretaker feels as though she or he are not being paid all of the wages that they're owed, what should they do?
Well, Gloria, I suggest that these employees contact an employment lawyer for a consultation. Employers may take advantage of nannies or other household employees in many ways. Unfortunately, we don't have time to get into all of them here. Only a personalized consultation with an attorney will give you a full picture of your rights. I also recommend that these employees try to, as best as they can, document how many hours per day they are actually working. And I stress actually, because even though an employee is not in the house, they may still be working if, for example, they go to the store to buy something for their employer, or if they travel with a family working as a nanny or a caretaker. Having some documentation of the actual hours worked is a big help in determining what an employee may be able to recover. Documenting these hours doesn't have to be too complex. Something as simple as getting a monthly calendar and writing in each day's box how many hours you worked that day will help a lawyer evaluate your case and determine how much you may be owed.
Byron, are there any wage and hour issues that workers should be aware of, especially now during this pandemic?
Yeah, Gloria, given the high number of layoffs during the pandemic, employees should be aware of their rights to their last paycheck and payment of unused vacation time or PTO, paid time off. In California, when an employer ends an employee's job, for whatever reason, employees are entitled to collect all earned wages the same day their job ends. If an employer fails to pay all earned wages at that time, then the employee can collect waiting time penalties for each day the employer is late paying them for up to 30 days. The same is true for any accrued vacation or PTO. This is not an exhaustive list, but these issues are highly relevant given the current high number of layoffs and furloughs, unfortunately.
Thank you, Byron. And that concludes our panel discussion today. Thank you to Maria Diaz, Marcus Spiegel, and Byron Lau. Remember that you can all feel free to join us next week for our next session of Know Your Rights. And to all of you who have joined us today, thank you so much for watching. Feel free to share your comments and your thoughts in the comments section of this post. If you have any specific questions about your own potential claim, our law firm is open, and we're continuing to provide free, confidential consultations about your rights. Come back next week to Know Your Rights. Take care and be safe.